advocate and patent attorney with over a decade of experience in dealing with IPR, including patents and trademarks. She is associated with research wings of several institutes to frame their IPR strategies and appears in various courts in Bangalore for her clients. She is the managing partner of Akim Legal Abode, a law firm based out of Bangalore, which handles and assists businesses, including startups, in various legal matters, from inception of a company to protecting their IP. Her primary focus areas are patent drafting and prosecution, IP litigation, training researchers of various educational institutes and startups on various aspects of patent, trademark, and copyright related areas. She is also associated with Intellectual Property Cell of IISC as an IP executive. Handled technology transfer deals for IISC inventions, drafting and negotiating research and license agreements, preparing, filing, and prosecuting patents, design, and copyright applications, and has managed outside counsels. She is instrumental in transforming the IP cell of IISC from a service facilitator to a service provider. She has involved in handling several research-based collaborations with industries. She worked towards pursuing a systematic, mutually beneficial engagement with research-based national and international companies in order to encourage them to partner with IISc. Ms. Brinda holds an MSc degree in biochemistry and biotechnology from Bangalore University. She has an LLB degree from Bangalore University and a post-graduation degree in business administration from Symbiosis, Pune. She is a registered Indian patent agent and qualified to practice before the Indian Patent Office. She is the recipient of Association of Overseas Technical Scholarship for Patent Experts. Ms. Brinda is also active in IPR and commercial law litigation and in the field of contract law. She is a regular speaker at various forums and has delivered talks to various research organizations across the country in the field of IPR, and is also involved in corporate training in the fields of commercial laws, contracts, and consumer-related laws. She has authored a chapter, namely Intellectual Property Rights and the Technology Transfer Process, for a book titled Treatise on Process Metallurgy. Also, she is associated with Vishweshwaraya Trade Promotion Center, Government of Karnataka, as an IPR consultant. We welcome you, ma'am.
Thank you very much. I would like to thank the KCST, Mr. Vivek, and of course the Biotechnology Department of your college for giving me this opportunity. And I know it is very difficult to really understand these concepts through these online classes, but I think it's a great effort from your college to ensure that you have this. I think a 2-week-long sessions to bring a lot of concepts on patent-related issues. Thank you very much. So I think all of you can see my presentation.
Yes, ma'am.
Okay. I'll just make it full screen so that, yeah. Well, the topic which was given to me was patenting of biotechnology inventions. And I think in the previous sessions, you must have got some introduction about what is intellectual property rights, and then the patentable aspects pertaining to probably focusing on the biotechnology inventions. So today I will try to focus on the relevant provisions under the Indian patent law for the biotech industry. So probably, when the inventors are going ahead and filing for a patent in this particular field, you would know which section is most important and how it needs to be handled and addressed, when you're filing for a patent or when you get some kind of an objections from the patent office. So specific focus is only on the Indian Patent Office. So in the next 1.5 hours, these are the aspects which I intend to cover. Of course, I'll give you a brief introduction of what is that I intend to cover, a brief history of the changes to the law pertaining to the biotech industry, and then a little about patentable subject matter and the provisions relevant to the biotech industry. So I'm going to focus particularly on those. And I'll give you two interesting case laws, and which is very, very relevant to your industry or to your discipline. So what is a patent? I don't have to get into these details, but yeah, I thought I should start with this, with probably one or two lines on this, because everybody needs to understand what a patent is all about before we file for it or seek any kind of protection for our invention. As a previous speaker would have already covered, it says a patent is a property right granted by a state to the inventor or an applicant of a novel, non-obvious, and useful invention. So we have these three criteria which is covered and should not fall under the ambit of inventions not patentable. So a patent is granted only when it meets these requirements. So requirement 1 is this novelty, requirement 2 is a non-obvious, and requirement 3 is it should have some kind of usefulness, right? Some application in the industry. So for instance, in your discipline, if you just go and identify a protein where you do not know what is it used for, okay, so you don't get a patent, although probably you've identified some new protein there. So this is just one quick example for you. So that is where useful invention becomes very important here. And inventions that are not patentable, although it meets the criteria of what I just mentioned, that is novelty, non-obviousness, and usefulness, despite meeting these three criteria, if it falls under the category of inventions not patentable, which is Section 3 of the Indian Patent Law, which I'm going to take you through to, then even then a patent will not be granted for your invention. So what does this right actually mean to a patent holder? This right means that owner of a patent can exclude others from making, using, offering for sale, or selling his or her invention for a period of 20 years from the date of filing of your patent application. So the period of 20 years is calculated from the date of you filing for a patent application, and it is not from the date it is granted. So that is why we say it becomes very important for you to analyze your priority date. The date of filing of your patent application is considered to be your priority date. Okay, so what rights do you have? You have the rights to exclude others from making, using, offering for sale, or selling. So that is the reason why we call it as a negative right. Of course, you have the right to do what you want to do with your patent, but you can, exclude others from also doing these activities. So invention in biotech field basically falls under these categories, and I've just tried to group them. And this is also based on the manual which is published by the Indian Patent Office. Okay, so you have gene engineering technologies, you have methods of producing organisms, methods of isolation of microorganisms from culture medium, methods of mutation, cultures, mutants, transformants, plasmids, process for making monoclonal antibodies, cell lines for making monoclonal antibodies, transgenic plants, animals, isolation of human genes for using them to produce medicaments. So these are some of the typical inventions which the Patent Office receives for grant of patents in your discipline. So moving on to a brief history of what kind of inventions in biotechnology field were actually patentable. Of course, the history. There were several biotech-related inventions which were patentable, but of course the term of biotechnology itself was coined a little later. So, but earlier, certain kind of microorganisms, the microorganisms with your human interventions were also considered patentable at that point of time. But let's see what does the Indian history say. So until 2002, okay, as per the prevailing practice of the Indian Patent Office, patents were not granted for inventions relating to living entities of natural or artificial origin, right? So living entities of natural or artificial origin, biological materials or other materials having replicating properties, substances derived from such materials, and any processes for the production of living substances, entities, including nucleic acids. So these were some, inventions where patents were not granted till 2002, which is not very old. But patents were being granted for processes of producing non-living substances by chemical processes, bioconversion, and microbiological process using microorganisms or biological materials. Right? We were restricting only to the processes of doing certain things, but not the product itself. When I say the product itself, I'm talking about the biological material itself. So till 2002, it was not. So when did it change? It changed in a particular decision by the Calcutta High Court in Domenico AG versus Control of Patents and Designs case. We popularly call that as. Okay, so this basically allowed grant of inventions for the final product, that is, for the biological material as a final product, despite it being a living entity, right? So this is where it changed. But what did this High Court actually, allow? So, sorry, I think I went back to the other thing. Okay, so here the court conclude that a new and a useful art or process is an invention. So they're trying to define what is an invention as when it comes to the biotechnology related field. So it says, included that a new and a useful art or process is an invention, and where the end product, okay, even if it contains living organisms. So if the end product also contains a living organism, is a new article, the process leading to its manufacture is an invention. Okay, so it says a useful art, any new and a useful art or process is considered an invention despite the end product having a living organism. So this was related to a process for the preparation of a live vaccine for protecting poultry against bursitis infection. Of course, a patent was granted here. So the control of patents initially had refused the application for grant of patent on the ground that the vaccine involved processing of certain microbial substances and contained gene sequence. So it was not allowed in the Indian by the Indian Patent Office. But of course, as I said, these changes, the court looked at it from a different perspective. So controller had decided that the said claim was not patentable because the claimed processes was only a natural process devoid of any manufacturing activity, and the end product contained living material. So this was a reason given to the patentee by the controller of patents. So as you know, the procedure is once a patent application is filed, it will be evaluated by the Indian Patent Office, and the Indian Patent Office will receive something called a first examination report stating whether your invention is patentable or not patentable. If it is not patentable, they'll have to give you reasons why it is not patentable under the conditions which I told you initially, that under what grounds a patent would be granted, right? So basis this, the controller, that is Indian Patent Office, clearly stated that it is devoid of any manufacturing activity and the end product contained living material, and hence it was rejected. Now here, the Honorable High Court held that the word manufacture was not defined in the statute, because in our enactment, it was clearly mentioned the process of manufacture, okay, should be considered for a patent to be granted. So here the court said that manufacture was not defined in the statute, therefore it actually tried to give a definition to it from the dictionary. So it says the dictionary meaning attributed to the word in this particular trade or business can be accepted if the end product is a commercial entity, right? So that is a definition which the High Court of Calcutta gave to the word manufacture. So the court further held that there was no statutory bar in the patent statute to accept the manner of manufacture as patentable, even if the end product contained a living organism. So let's try to understand how the court, tried to basically differentiate the word manufacture and try to see how it can involve a living organism under the word manufacture as well. So the court basically came up with something called a vendability test, right? So the vendable, so it started considering or treating this living organism, that is the end product containing the living organism, as a vendable item. And I think it's fair enough to deal with it. So the said test would be satisfied if the invention resulted in the production of some vendable item, or it improved or resorted the former conditions of the vendable item, or its effect was a preservation and prevention from deterioration of some vendable product. So the court further stated that the vendible product meant something which could be passed on from one man to another upon transaction of purchase and sale. In other words, a product should be a commercial entity, right? So based on this, it said that that particular invention is a vendible item, and because of it, a patent should be granted, irrespective of whether it has a live organism or not, as an end product. Okay, so that is what it considered. And in addition to the judgment by the Honorable Calcutta High Court, in the year 2002, in the same year, the Patent Act also was amended, and where it started incorporating other aspects, which is where biochemical, biotechnological, and microbiological process were included within the scope of what is called as chemical processes for the grant of a patent. So it expanded the scope and didn't restrict itself only to chemical process, but it went beyond that. So that is where there was, a change in the way a biotechnology inventions was considered while for filing for a patent or grant of a patent. So the definition of invention also changed. So it became to any new product or process involving an inventive step and capable of industrial application. So the word manner of manufacture, which was part of the definition, was deleted. So this actually enabled several grant of biotechnology inventions because it focused only on these three aspects and the manner of manufacture was not considered. So that is a little bit about the history. So let's move on to the very important aspect, so which is considered to be a patentable subject matter. So I didn't want to go into the details of novelty, inventive step, and the application of your invention, because I think that would be dealt by another speaker. I don't know if it has already been dealt, but so my focus is primarily to make you understand of the other aspect of considering while grant of a patent by the Indian Patent Office, or when you're also filing for a patent, or when you're developing some interesting invention. So you should also keep in mind that these are something which has to be considered when you're trying to file for a patent. And the first, the three criteria which I mentioned is the same across the globe. It's not that in India it's different and outside India it is something else, but it is more or less uniform. But the definition of each one of the definition of each of these criteria might vary slightly depending on the which country you're going and filing for a patent. Now, the patent subject matter, what I'm talking to you about, is very, very typical to the Indian Patent Office. Some part of it is also covered by the other patent offices, but this is very typical of the Indian Patent Office. So, what is invention? We have already discussed this in the previous slides, right? I will not get into the details of it, but I think all of you know that invention must relate to any kind of a process or a product which should be novel, involves inventive step, right? So I'll just move on to this. Possible biotech inventions. I think I have already covered few things in the biotech related inventions, but these are in addition to that. So you have the polynucleotides or gene sequences, which are also considered as patents these days. So these are some of the inventions which have been filed before the Indian Patent Office too. So polypeptides or protein sequences, which is both product and process. Vectors, examples are plasmids, both products are process. Gene constructs or cassettes and gene libraries for cells, microorganisms and stem cells, plants and animals, tissue culture. So it can be both products and process. Pharmaceutical or vaccine composition comprising microorganisms, proteins and polynucleotides. So again, products or process. Antibodies or antigen binding fragments thereof can be both monoclonal or polyclonal. Diagnostic kits and tests. Okay, and diagnostic tests is also very, very important area which is coming up, which is products and process, such as a test for the detection of a mutation in a gene or a protein, which might be associated with a particular condition, such as a protein expression or a disease, right? Now, there's a lot of patent applications being filed in this particular area now, based on the diagnostic kits, which contains, which basically relates to a detection of a mutation in a gene or a protein. So going to the section 3, you have several sections which are under section 3 you have several subsections which basically lists out the inventions that are not considered to be patentable. But for this audience, we thought we'll restrict only to the provisions relevant to biotech related inventions. So I'm going to start with section 3B. So this is the section 3B of the Indian patent law, which basically says any inventions which are contrary to morality or which cause serious prejudice to human, animal, or plant life or health or environment. So inventions, despite meeting the criteria of novelty, inventiveness, and application, the usefulness, if it is contrary to morality or can cause serious prejudice to human, animal, plant life, health, or environment, look at that, they have covered everything here, okay, would not be patentable. So some of the examples relevant here would be process for cloning human beings or animals. We haven't gone to an extent of granting a patent for that because we felt that it is against contrary to morality and may cause serious prejudice to the nature. So process for modifying the germline of human beings, a process for modifying the genetic identity of animals which are likely to cause them suffering without any substantial medical or other benefits to man or animal, and also animals resulting from such process. A process for preparing seeds or other genetic materials comprising elements which might cause adverse environmental impact. Okay, I'm restricting this only to India. Of course, some of these have been patented in other countries, but in India, no. We are not, Indian Patent Office does not grant patents if the inventions fall under these categories. This is just some of the examples. After section 3B, we have something called a section 3C. Okay, section 3C. So 3 basically is inventions that are not patentable for people who have just gotten up. So section 3C covers discovery of any living thing or non-living substances occurring in nature, right? So Indian Patent Office tries to differentiate between a discovery versus an invention concept. So a patent is granted only if it's an invention, but if it falls under the category of discovery, no, a patent will not be granted. So that's why it says discovery of any living thing or non-living substance occurring in nature. Now, examples include products such as microorganisms. Now, again, there might be a question here if you've already heard speakers say, okay, microorganisms also patentable. So I will let you know under what circumstances microorganisms are patentable. But microorganism, which is just available in nature, and then you discover that microorganism for a particular property, then it's of course not patentable because it will fall under the category of discovery. Nucleic acid sequences, proteins, enzymes, compounds, etc., which are directly isolated from nature, are not considered to be patentable subject matter. Okay, so one of the case which is from the Indian Patent Office. Let's see what the invention is all about here. So a bacillus species, it has a code which is given comprising ribosomal DNA. Okay, and it was a sequence wherein the sequence ID was identified. So that is a sequence which they wanted to patent, but related to the bacillus species. Okay, so that was the invention. And there is some deposition number. I'll tell you what it is. Probably the subsequent slides will give you more clarity on it. But in brief, a bacillus species with a particular ribosomal DNA sequence. Okay. Now, the response from the Indian Patent Office, it was rejected. This invention was rejected for the reasons as below. It said the subject matter of claim falls within the scope of Section 3C. Why? As it attempts to claim an isolated bacillus species, okay, which is basically a living substance occurring in nature. And this is what was described in the patent application. Basically, it was picked up from soil. Okay. So what is claimed in the claim is treated as a discovery of a living thing occurring in nature and hence not patentable. Right? Although they have isolated the species and the particular sequence, but it was not considered to be patentable because it was something which was already occurring in nature. So just picking up something occurring in nature and trying to patent a sequence from that is not considered to be patentable because it will fall under Section 3C. Probably it is novel, probably it is inventive in nature, right? But it falls under the category of discovery and hence not patentable. The other section is Section 3D. So Section 3D basically says a mere discovery of any new property or known use for a known substance, or of the mere use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. So I think if you understand this. So what is not patentable? A mere discovery of a new property or a new use for a known substance, or of the mere use of a known process, machine, or apparatus is not patentable. Okay. However, it can be patentable if such known process results in a new product or employs at least one new reactant. Okay. So which means if you try to discover any new property of a known product, right, or a known process, is not patentable. So it further actually gives you an explanation. Salts, esters, ethers, polymorphs, metabolites, pure form, particle size, isomers, mixtures of isomers, complexes, combinations, and other derivatives of known substances, okay, are considered to be discoveries or considered to be new property or a new use. So and hence not patentable. So shall be considered to be the same substance unless they differ significantly in properties with regard to efficacy. So under Section 3D, what you need to prove is if it is a new discovery of a new property, you will have to prove the efficacy. When I say efficacy, which means to say you will have to prove it stating that this is definitely much, much better than the existing product. Okay, and how is it better? To what extent it performs in a better manner than the existing product? If there's a substantial increase in the efficacy, then of course the patent office will consider, and then a possibility of granting of a patent, of course, on a case-to-case basis will be analyzed, and a patent will be granted. Very subjective in nature, but the patentee needs to prove the efficacy. So one of these such examples, I think it is still visible, right? Yeah, one of such examples is before the patent office which came was a pre-protein A being one of the factors which primarily control glucose metabolism in mammals, having C-peptide, wherein said C-peptide comprises 2 amino acids selected from XY, YZ, and ZX. Right? So here, what the inventor claimed, what the applicant claimed was a pre-protein A being one of the factors which primarily had glucose metabolism control in mammals, which had the C-peptide, and the C-peptide contained 2 amino acids selected from this group, XY, YZ, and ZX, right? Out of these 3, any 2 were selected. Now, how did the patent office analyze? They said prior art discloses. So they have identified certain prior art and stated that certain prior art, whatever they've identified, discloses modified protein A having C-peptide, wherein said C-peptide consists of amino acid X and X. Okay. So here, if you see the claim, it says selected from XY, YZ, and ZX. So XY and ZX. So there are 2 components there. So the prior art had a C-peptide consisting of the amino acid XX. So the applicant failed to demonstrate any therapeutic efficacy as a result of claim modification over the prior art. Okay. So therefore, the patent office rejected, stating that it falls under the provision of Section 3D, and hence invention cannot be patented. A patent cannot be granted. The next one is the section 3E. So it states that substance obtained by mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance, right? So if the invention is only a mere admixture or an aggregation of the properties of the components which is already available in the public domain, then it is not patentable as per section 3E. Examples, combi flame. So basically a combination of paracetamol and bruphene, right? So then it gives you the properties of both combined. So that is why it is not patentable. Solution of sugar and color additives in water to form a soft drink, not patentable. However, a mixture resulting into synergistic properties. So the minute they're combined, if it gives you some kind of a new synergistic property, which is not anticipated, which is not expected by a simple combination, then of course, such inventions are patentable. So properties of mixture of ingredients, however, may be patentable. So like examples, soap, detergents, lubricants, etc. are synergistic formulations. So let's see another example from the patent office. So here the claim in the patent application was a composition of innovative combination of dormant. So for people who don't understand what a claim is, for people who don't understand how a patent application will be drafted, I think you have, or I'm not very sure if you've already finished a session on that, but you will definitely have a session on, the contents of a patent application, what needs to go into a patent application, what is a prior art, how does a prior art analysis, would be conducted. These are some of the sessions which are already covered in your, the 2 weeks agenda. So claim is an important part of the patent application because that is the one which defines the boundary of your invention. That basis on that claim is where a patent office will analyze your invention and grant you a patent. Okay, so that's where we are trying to see what a claim is and then see how the patent office has analyzed that. So a claim is so the claim for this invention was a composition of innovative combination of dormant spore of naturally occurring Paecilomyces elacinus and Arthrobotrys species fungus, okay, which is a fungus with enzymes, fats, and growth promoting molecules to control plant parasitic nematodes. Okay, so here, what did the patent office basically respond? It's stated that the subject matter of claim falls within the scope of section 3E and hence not patentable because upon the examination, it found that the claim is directed to a composition of two known fungal species. Okay, so the said species used in the invention are known for their nematode biocontrol activity. So they found that based on the prior art that these two species were already known for their nematode biocontrol activity. So the specification what was disclosed is silent on advantages of a combinative effect, right? Although it says it is a combination of two species, but it did not give what are the advantages of combination because ultimately the application part was for a nematode biocontrol activity and the patent office identified that this is the feature of these two species even if you take them independently and handle them independently over the sum of their individuals. So the specification is silent on advantages of a combinative effect of these two fungal species over the sum of their individual effects, right? Hence not patentable under section 3. So you can see how the patent office is actually looking at it to analyze whether it falls within the ambit of inventions not patentable of section 3. The other one is method of agriculture and horticulture. So section 3H basically says any inventions which fall under the ambit of method of agriculture and horticulture is not patentable. So if you have your regular agriculture or horticulture process, no, it's not. So a method of growing leguminous plants as intercropping for improving fertility of soil by augmenting nitrogen content of the soil. Okay, so this was a claim and before a patent office. So as an example, a method of growing leguminous plants as intercropping for improving fertility of soil by augmenting nitrogen content of the soil. I think by now all of you would have understood what this invention is all about. So here it says it is a typical agriculture method which is used by several people, and or even if it is not used, because it's an agriculture method, it's not patented. So there was another case here, a method of reducing mycotoxin contamination of a plant or harvested plant material. Okay, it involved treatment of seeds with the chemicals before sowing or during sowing in the field for the plant cultivation process. Okay, so basically a method for treating pre-treatment of seeds with chemicals before sowing. So that was an invention to reduce mycotoxin contamination. So again, the patent office held not patentable under section 3H. The other important exclusion here is section 3I. So method of treatment and diagnosis. So it reads, any process for medicinal, surgical, just try to see how the various aspects have been covered under this. Process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or a similar treatment of animals to render them free of disease, or to increase their economic value or that of their products. So anything related to these processes is not patentable as per section 3I. Okay. But of course, a diagnostic kit, a surgical instrument, these are patentable. So here we are talking about a process for these aspects is not patentable. So this basically was to, earlier, for example, a surgical method. Doctors with experience used to evolve different surgical methods, and now, when they started filing for a patent of the surgical method, it created a lot of issues because the other doctors were not able to utilize or use the same surgical method to treat the patients. So considering that, I think this has evolved over a period of time, and across, this has come up stating that these are something which cannot be patentable because it should be available to everybody, to entire public, so that they benefit out of such inventions. And there should not be any restriction upon use of those inventions. So some of the examples are removal of cancer tumor, removal of dental plaque and caries, surgical processes, processes relating to therapy, methods of vaccination, blood transfusion methods. So these are something which are not patentable. So as I said, surgical, therapeutic, or diagnostic apparatus or instruments are patentable. Okay. And treatment performed on tissues or fluids permanently removed from the body. Okay. So that is also patentable. So the means which are permanently removed from the body and then you treat something there and then the process utilized in that is definitely patentable. But within, no. So that's where your in vitro and in vivo differentiation is being provided by the patent office. So one example again from the patent office. So a method of monitoring drug response in a patient suffering from cancer treated with a combination of these two things, gemcitabine and P1446A, comprising detection of a gene signature with at least 2 drug response markers, wherein the said drug response markers are selected from the group consisting of P21, REV3L. So these are various gene combinations which they have picked up. Okay, so this is the claim. This is the invention which was before the Indian Patent Office. And what the Indian Patent Office stated was, it is directed to a method of diagnosis of human beings or animals which are statutorily barred from the patentability under Section 3 of the Act, hence not patentable, right? Because if you see, it is comprising detection of a gene signature with at least 2 drug response markers. So the minute it says detection of a gene signature with at least 2 drug response markers, then they felt that it falls on, it is a method of diagnosis and hence cannot be patentable. Section 3J. Now, Section 3J says plants and animals in whole or any part thereof other than microorganisms, right? Earlier in one of the sections, I had told you that any discovery, okay, including microorganisms, are not patentable. So let's see what here 3J says. So you will have to read these two sections in combination. So plants and animals in whole or any part thereof other than microorganisms, but including seeds, varieties, and species, and essentially biological processes are excluded from patents. So if the microorganism is only a discovery, okay, which is available in nature, then no. But if the microorganism is an invention, when I say invention, is something which is developed with human intervention, then of course it is patentable. So any modification to the naturally occurring microorganism is patentable, right? However, the naturally occurring microorganisms per se is not patentable. So in addition to that, it says plants and animals in whole or any part thereof is not considered to be patentable. So one of such examples again here is a method of producing at least one of substantially pure hybrid seeds, plants and crops comprising the steps of. So this is again a method related to pure hybrid seeds, plants, and crops. Okay, producing a male parent which is male fertile, breeding the male parent with a female parent which is substantially male sterile, and harvesting seeds from the female parent which contain pure hybrid seeds. So this was the invention. Now here, the analysis was the claim method involves a step of crossbreeding for producing pure hybrid seeds, plants, and crops. Right? So if you look at the claim, that's what it says. Steps of producing a male parent which is fertile, then breeding the male parent with the female parent is substantially male sterile. So they have identified the best cross, then harvesting the seeds from the female parent which contain pure hybrid seeds. And since they said that it is based on the crossbreeding for producing pure hybrid seeds and a method which falls under section 3J and hence not patentable. The other section is section 3K. The computer programs person, algorithms, mathematical methods. Now, how is it relevant to the biotech industry? I don't think I would have to tell you that because bioinformatics is very popular. And I think this is one of the relevant clauses to see how that is addressed. Okay, I will discuss this with one of these cases, which is a very interesting one. So what does the invention say? And this computer programs per se and algorithms, mathematical methods is not restricted only to biotech inventions across all disciplines, particularly for the software industry also. Software per se is not considered to be patentable unless there's a hardware associated with it. Okay, so this is also relevant for this particular domain. So the claim reads as follows. A computer-assisted method of generating a compound that inhibits the glutamine formation active site activity of a glutamine synthetase polypeptide, wherein said test compound is capable of inhibiting the interaction between an adenylated catalytic triad site of the glutamine formation active site and a glutamyl phosphate intermediate, or of inhibiting the interaction between a de-adenylated catalytic triad site of the glutamine formation active site and a glutamyl phosphate intermediate. The method comprising the steps of providing a three-dimensional structure of a glutamine formation active site of a glutamine synthetase polypeptide and a designing based on the three-dimensional structure a test compound capable of inhibiting the interaction between the glutamine formation active site and a glutamyl phosphate intermediate. So this is what the method is to achieve the preamble of the claim. So the patent office has analyzed and said The claimed method is considered as a mathematical method or computer program per se, as it relates to a method of designing the inhibitory compound based on the 3D structures, but does not lead to a real product whatsoever. Thus, the subject matter of claim falls within the scope of statutorily non-patentable inventions under Section 3K. So here you see, nowhere they're talking about a real product. Okay, so it is all basis on the inhibitory compound probabilities on the three-dimensional structure. So hence it was considered not patentable. So the last subsection under the Section 3 exclusions is the Section 3P, which is also very, very important. So under Section 3P, inventions which are in effect traditional knowledge or which is an aggregation or duplication of known properties of traditionally known components is not a patentable subject matter. So again, you can see that it's focusing only on the traditional knowledge. Okay, so this is basically to avoid the exploitation of the traditional knowledge and patenting of the traditional knowledge related inventions. So it says in effect traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components. Okay, is not patentable. So one of the examples which has come before the patent office, a serum of pigeon possessing the anti-paralysis activity. Okay, so the invention, the claim was pertaining to that, and the patent office said that the use of pigeon serum for the treatment of paralysis, as it possesses anti-paralytic activities, a traditional knowledge in India, or is an aggregation or duplication of known properties of traditionally known component. Okay, so they could identify some of the prior art relevant to that, and then clearly stated that it is not patentable because it falls under the category of Section 3P. So one of the prior art clearly establishes that the use of pigeon blood for treating paralysis, right? So basis that they said no, because it falls under the traditional knowledge concept and very well known in India for the treatment of paralysis. Hence not patentable. So the sections which I've just listed out, you can see the way they have tried to cover and clearly mention that these inventions, despite meeting the requirement of the three important criteria, is not patentable. And this was included keeping in the mind of the interest of public at large, right? Because the minute you have a patent on some of these factors, you will have a monopoly for 20 years. So when you have a monopoly for 20 years, nobody will be able to go ahead and use it for the benefit of the public, considering that the patent office has exhaustively evaluated and said, now these are something which needs to be excluded despite it meeting the criteria, and ensure that a patent should not be granted if the inventions fall under these categories. Another important concept or provisions, which probably is relevant to biotechnology and of course pharmaceutical industry also. Now, some of these sections which I just read out, under the non-patentability is also related to pharma industry, and of course other industries too. But yeah, pharma and biotech industry, yes, they're closely, these sections are closely related and probably would be relevant even for that particular, for pharmaceutical industry as well. So another important concept which I think inventors should understand is there's something called a compulsory licensing option. Now, why am I talking about this compulsory licensing option? I thought people should know that say if your invention meets all the criteria, and it does not fall under the scope of Section 3 and meets the 3 important criteria, and a patent is granted, and you would have your 20 years monopoly. But the patent office has put some checks and balances stating that despite you having that kind of a monopoly, the government at any point of time can actually step in and say, look, this invention is required for the benefit of public, and hence you are supposed to grant a compulsory license to ensure that it meets the requirement of public. So for instance, at an emergency situation, for our, the current situation. So if there is a drug maker, or, we are talking about vaccines here, so goes ahead and files for a patent, no problem, they can go and file for a patent. And if he says, okay, now I have got a patent, so but I'm going to restrict myself to only certain licenses, or I'm only going to manufacture and release only these many vaccines to the public. So what is going to happen under those points? So of course, there is a requirement, there is a demand. It has to be, provided, vaccine has to be provided to every individual in the country. So at that point of time, if a patent holder says, I have a patent, and it's my right, I will decide whom I need to give, at what price I will have to give, and at a time I need to give, then it is very, very risky for the country, right? So considering these kind of situations, the concept of compulsory licensing was brought in, and wherein the government of India can march in at any point of time and say, look, you are the patent holder, but there is a requirement now. Irrespective whether you say yes or no, we have a right to take it and ensure that the public benefit out of it. So that is where the concept of compulsory licensing is coming. And it's just, I think, considering the current situation, I think it's very, very relevant how these clauses actually made sense to be incorporated into the patent office. And mind you, not all jurisdictions, all countries have this kind of provision. Okay, so India is one such country which has really thought about it and included this particular provision. Two relevant sections, section 84 and section 92A, but I will not get into the details of that. But if anybody is interested, you can definitely read that. So enables to grant compulsory license to export pharmaceutical substances to any country which does not have proper infrastructure to manufacture and bring remedy to country's requirement. You can see that we also have a provision that, you can even go ahead and export your pharmaceutical substances to any country so that it meets the requirement of the country. So section 84 of the compulsory license of the Patent Act says, at a time after the expiration of 3 years from the date of a grant of a patent, any person interested can make an application to the Patent Office for grant of compulsory license on any of the following grounds. Ground 1, if the reasonable requirements of the public with respect to the patent and invention is not being satisfied, or that the patented invention is not available to the public at a reasonable, affordable price. 3, the patented invention is not being worked in the territory of India. So that I think covered more or less everything. So under these 3 circumstances, okay, after the expiration of 3 years from the date of a grant of a patent, any interested party can go ahead and request for a compulsory license from the Patent Office directly. So in the event they go to this patentee, and if the patentee rejects granting them a license, they can always approach the Patent Office and ask the Patent Office to issue a compulsory license. And if the following, any one of these criteria are met, okay, it is not and, it is or, any one of these criteria are met, then of course the Patent Office can go ahead and grant a compulsory license. In addition to this, the other provisions, which I think also be relevant here, would be section 10.4, where the sufficiency, it actually talks about sufficiency of disclosure, the best method of performing the invention. And section 10.5, unity of invention and clarity, succinctness, and support of the claims. Now, I'll not get into the details of this because, when a speaker is talking to you about the drafting of a patent application, the contents of the patent application, they would cover this. But I just thought I should give you a heads up stating that these are other relevant sections when it comes to the to what extent you need to disclose and how you have to actually draft the patent application and what needs to be considered. these two sections would become relevant at that point of time. In addition to the section 3, if you do not meet certain other criteria and parameters laid down by the patent office, even then a patent application would not be granted, despite you meeting the criteria, okay, and the invention not falling under the inventions under the section 3. Okay, so there is some concept called a deposition of biological material. So if you are working on any biological material, and if that biological material is new, then of course you will have to go ahead and deposit that in a depository, which is identified by the Government of India, or we also have an international depository authority. So it should either be, it will be identified by that, of course, with the permission from the Indian government. So they both under the international guidelines, Indian government has identified currently 2 depository centers. So it's called the Microbial Type Culture Collection and Gene Bank, MTCC in short, which is based out of Chandigarh, and Microbial Culture Collection, Pune. Now these are the 2 organizations where any biological material which you think you would want to patent should be deposited here, and only upon the deposition and you giving the deposition number to the Indian Patent Office, a patent will be granted. Without deposition, a patent will not be granted. Now, the reason why it has to be deposited is to ensure that tomorrow if somebody would want to use this, they can always use it. They can even evaluate to see whatever you have claimed in your patent application is correct or incorrect. Okay, so they have to have some kind of a source to actually get hold of what you have invented. And this is how the centers were identified. So across the globe, you have different centers identified for each country. So this actually is part of an international treaty. It's called the Budapest Treaty, and it focuses only on the International Depository Authority identified by the under the Budapest Treaty also. Okay. And as per the Indian patent law, the deposit of the material shall be made not later than the date of filing of the application in India. Okay, and a reference of the deposit shall be given in the specification within 3 months from the date of filing of the patent application in India. Right? So before you think of filing for a patent, you can just go ahead and deposit it. It's not difficult. You can just give a call to these collection centers. They will go ahead and share certain forms to you through your email IDs. You will have to fill in those forms and send the vial as per their requirements. Okay, they will give you, once you disclose what material it is, they will give you the details of how it needs to be shipped to them. And once it is shipped to them, they test and then they give you this number, and that number has to be disclosed to the patent office. So in that, all the available characteristics of the material required for it to be correctly identified or indicated to be included in the specification also. Okay, including the name, address of the depository institute, and the date and number of the deposit. So these are the details which you'll have to give both here and in the patent office also, and to the depository center as well. So please do not forget, whoever is working on some kind of a biological material, these depositions should happen. The next relevant thing is the biodiversity related issues. So India has a Biological Diversity Act in 2002 is when it was came into force. Okay, and this basically provides a mechanism for access of the genetic resources and benefit sharing accrue therefrom. Okay, so this is a kind of a way to protect our traditional knowledge and to protect the indigenous people who have been using these kind of genetic resources from ages. So it's not that we exploit them and they don't get any benefit out of it, right? So this is one of the kind of a mechanism involved to ensure that there is some benefit shared to these indigenous people as well from the country. So the Act says no intellectual property rights, including patents, based on research or information on biological resources obtained from India shall be granted without the approval of the NBA. Right? The minute you say that you have picked up some kind of a genetic source from so and so place, probably even, I'll give you an example. Say even for, if you're doing some research on curcumin, okay, and you have said, and you have told them very clearly from where you have obtained this curcumin from. In case you're obtaining curcumin from you extracting from the turmeric, then of course that is something which you will have to disclose to the biological diversity authority, stating that you have used turmeric for your invention where you have extracted curcumin, okay, and this turmeric probably would have bought it from a market as a commodity, or you have grown it probably in your kitchen garden or whatever. You need to disclose it to them, and then only upon them evaluating, they would go ahead and give you permission. In fact, even if you go and pick up this curcumin itself, which is available in some of the stores, so some of the companies dealing with these chemicals, who go ahead and sell, for example, Sigma Rich as a company, you can go and pick up this curcumin from there. Even then, if you have gone ahead and picked it up from curcumin, you're still supposed to go and seek permission from the NBA, because it is not only the biological sources, but it is also the knowledge. Okay, so everybody knows what is curcumin used for. Because you have gone ahead and used that knowledge for the benefit of your invention, the Act actually says that you need to go and seek permission from the NBA. Now, to what extent it is relevant, I don't know. But there are several issues pertaining to that. But that's what the Act says. Even the knowledge of that biological material, which is available naturally, okay, should be disclosed to the NBA and sought, and you will have to seek their consent for filing for a patent. So this has to be done before the patent is actually approved. And in fact, earlier that was not a mandate, and patent office used to go on and grant. But now there is an amendment to the Patent Act which clearly says the patent will not be granted the minute there is a mention of any kind of a biological, any kind of a genetic resource or a biological resources used from the country, obtained from the country rather, used or obtained, yeah. So the objective is to facilitate this access and benefit sharing, and in order to prevent any unauthorized use of the biological resources of India, Section 10 of the Patent Act amendment was made, okay, and one needs to seek permission. So also to prevent misappropriation of biological resources and traditional knowledge of India. There were several pharmaceutical companies who were seeking benefit out of it, going ahead and, exploiting the traditional knowledge available in India. I just gave you an example of curcumin. So they identified the key molecule in that particular plant, okay, and go ahead and synthetically manufacture that and sell it and get a patent out of it. So to basically avoid those kind of exploitation and the misappropriation, this has been inserted so that the pharmaceutical companies do not go ahead and misuse. So definitely permission would be granted, not that it will not be granted, but there would be a check which says that if you go ahead and reap any benefits out of this biological material or the knowledge which is available in India, you are supposed to give certain percentage of your royalty to the NBA, okay, and then NBA will go ahead and identify who are these indigenous people who are actually using this traditional knowledge, and they go ahead and share this amount with those indigenous people. So this is one reason, and I think a nice way to actually handle it and ensure the indigenous people also benefit out of it. So the reason I brought this out is for you to ensure that these are two important aspects which you need to go ahead and ensure that is complied with before your patent has been granted. Otherwise, the patent would not be granted. So this is whatever I've dealt with is basically to let you know the important provisions which one needs to keep a tab on even before you start your process of building some new technology or coming up with new projects or inventions. Keep all these in mind. And once it is already generated, you have your interesting invention in place. Even then, just ensure that you meet with all these criteria and you follow appropriate procedures and comply with the required sections and the rules of the Indian Patent Office. Said with regard to the Budapest Treaty, for you to deposit your biological material, okay, there, at that point of time, if you deposit in one center anywhere in the world, so if you're depositing as an Indian citizen here in the MDCC, Chandigarh, then you can use the same deposit number if you're going and filing for a patent outside the country. So if you're going and filing for a European patent application or the US, you can actually give them the same deposition number and that will be valid across the globe in any of the countries. The reason why is because we are the member of the Budapest Treaty and our centers are recognized internationally. Okay. So with that, I would actually take you to two important case laws which I felt is relevant, and due to the paucity of time as well, I've restricted myself only to these two. And after completion of these two case laws, I think we will open the forum for any kind of question and answers you might have pertaining to the session which, and the material which I've just discussed. So, Mayo versus Prometheus Labs. This is one of the very, very important cases, and I don't know if all of you have already read something about it in the newspapers. And these two cases are the US cases from the United States Patent and Trademark Office, and some of these are also relevant here because to some extent India actually considers some of the principles laid by the USPTO, or probably sometimes principles laid by the EPO, the UK Patent Office. Right, so that is the reason why I had to pull these two, which is relevant, and it's creating a lot of. Several patent offices across the country have considered the decisions of these two cases and started incorporating into their evaluation process. Okay, here the facts are: the respondent, who is the Prometheus Labs. So this is a case between two organizations, Mayo and Prometheus Labs. Was the sole and exclusive licensee of the two patents at issue, where which was relevant to thiopurine drugs to treat autoimmune diseases. So now, what are these? So when ingested, the body metabolizes these drugs, producing metabolites in the bloodstream. So because patients metabolize these drugs differently, doctors have found it difficult to determine whether a particular patient's dose is too high, risking harmful side effects, or too low and so likely ineffective. Okay, so the patent claims here set forth processes involving researchers' findings that identify correlations between metabolite levels and likely harm or ineffectiveness with precision. So each claim recited instructions to a doctor to administer the drug to his patients, telling the doctor to measure the resulting metabolite levels in the patient's blood and describing the metabolite concentrations above which there's a likelihood of harmful side effects and below which it is likely that the drug dosage is ineffective, and informing the doctor that metabolite concentrations above or below these thresholds indicate a need to decrease or increase respectively drug dosage. So this was the invention. Okay, so what did they do? So the petitioners, Mayo, bought and used diagnostic tests based on the Prometheus patents. Okay, so the correlation aspect was the one which they had patented, and then Mayo bought this. In 2004, Mayo announced that it intended to sell and market its own diagnostic test. Okay, that is where the issue cropped up. So Prometheus sued Mayo, contending that Mayo's test infringed its patents. When it went to the US District Court, the District Court found that the test infringed the patient's patent but granted summary judgment to Mayo, reasoning that the processes claimed by the patents effectively claim natural laws or natural phenomena, namely the correlations between thiopurine metabolite levels and the toxicity and efficiency of thiopurine drugs, and therefore not patentable. So the district court started analyzing, stating that whether in US natural laws or natural phenomena is not something which is patentable. So they started analyzing on those terms. Similar to in Indian patent law, when I spoke about section 3B, discoveries, something which is occurring in nature is not patentable. So in US, you have something called natural laws and natural phenomena, okay, which is not patentable. So it was appealed. The Federal Circuit reversed the finding and said the processes is patent eligible, okay, under the circuit's machine or transformation test. So they try to put forth a step to see whether it meets the patentability requirement. On demand to the district court, okay, for consideration for a case which clarified that the machine or transformation test is not a definitive test of patent eligibility. Okay, and the Federal Circuit reaffirmed its earlier conclusion and certiorari was granted. So basically stating that it should be patent eligible. So the issue at hand was whether the processes which was patented by Prometheus was patent eligible or not, based on the natural phenomena principle. Okay. Now it went, of course, to the US Supreme Court, and the court held that the Prometheus process is not patent eligible. So processes that purportedly helped physicians determine proper dosage levels of thiopurine drugs used to treat autoimmune diseases are not patent eligible under US laws. The US Supreme Court unanimously held that the patents were not patent eligible since the relationship between concentrations of metabolites in the blood and the likelihood that a thiopurine drug dosage would prove ineffective or cause harm were known laws of nature, and the patients did not describe genuine application of those laws. Right? So look at the way they try to understand the relationship between the concentration of the metabolites in the blood and the likelihood that the thiopurine drug dosage would prove ineffective or cause harm. So you decrease or increase, of course, there is some kind of correlation which the invention was only focusing on. So the steps of administration of the drugs by physicians who already use the drugs, advising the physicians to apply the natural laws in making treatment decisions and directing the measurement of metabolite levels were well known, and simply told the physicians to engage in well understood routine conventional activity previously engaged in by scientists in the field. Further, considering the steps as an ordered combination added nothing to the laws of nature and was not already present when the steps were considered separately, and there was no inventive concept in the claimed invention of the natural laws. So considering these aspects, the Supreme Court of the US clearly said that it is not patent eligible. The other important case is pertaining to the Association for Molecular Pathology versus Myriad Genetics Incorporated. So that gene patent was based for breast cancer screening. So they had two genes, BRCA1 and BRCA2 are two genes linked to susceptibility for breast and ovarian cancer, right? The risk of falling ill increases if these genes show certain mutations. Identifying the mutations is therefore important for diagnosis and for monitoring higher risk of breast and ovarian cancer in women. So Myriad Genetics, in collaboration with the University of Utah, were the first to sequence the BRCA1 gene and applied for patent protection in 1994. So this is an old case, but there was a change in the decision, last few years back. So together with the University of Utah Research Foundation and the United States of America Research Foundations, Myriad holds US patents. Basically two patents, which is the number which I've just given, 5747282 and this, on the isolated DNA coding for a BRCA1 polypeptide and on a screening method. Okay, so they have the the BRCA1 polypeptide and also the screening method. So these were the two inventions which they claim. So in 1997, together with one of the research centers in Canada and the center and the one of the Cancer Research Institute of Japan, they received a protection on an isolated DNA sequence, asserting rights over a number of mutations in the genes. Okay, so they actually, their claims encompassed everything pertaining to this. So subsequently, patent applications are also filed on the second gene, that is BRCA2, and other countries, in both US and other countries, and patents were granted, okay, because it met all the requirements of the US patent law. So these genes were instrumental in diagnostic breast and ovarian cancer among women, because women possessing these genetic mutations were more susceptible of having breast cancer, nearly 50 to 80%, and ovarian cancer, nearly 20 to 50% later in their lives. Okay, so it was a fantastic mechanism to diagnose the possibilities of both ovarian and breast cancer. So, Myriad threatened to sue any lab which was offering tests for BRCA or related genes without seeking license from them. So the company took complete advantage of the exclusive rights that the patent has vested on it. It charged humongous costs for the diagnostic test, so the actual price accrued was not even a fraction of the amount that was charged. So, and over a period of time, it also stopped sharing data with the scientific community. So this is an example of a classic example of a gene monopoly. Okay, so it was impossible for others to actually go ahead and utilize these without their permission, including the data, because they stopped sharing the data, and it became very difficult for the scientific community and for the doctors to, or the diagnostic laboratories to actually go ahead and offer these tests. So in year 2010, a case was filed against Myriad by a group of several experts physicians. So you can say that it's kind of a people who were against granting patents for these. Everybody came together and went ahead and filed for a validity of these patents. Look at this. Even after a patent was granted, the validity of the patents was questioned for these two genes in 2010. So when was it filed? In 1994, and in 2010 when these issues came out. So the matter was brought up by the plaintiff for the District Court of New York, and the court ruled in favor of the plaintiffs in March 10. Okay, and it stated that the patents at issue directed to isolated DNAs. Try to understand this. At issue directed to isolated DNAs containing sequences found in nature, okay, which are unsustainable as a matter of law and are deemed as non-patentable subject matter, and thereby invalidating patents on the BRCA1 and BRCA2 genes. So it clearly said that it directed to isolated DNA containing sequences found in nature. So Myriad moved to the US Court of Appeals for the Federal Circuit by way of an appeal. And it was people who actually followed, they would understand, it was a very interesting switch. Some part of it, the US government, actually supported. At some point of time, the government didn't support. Actually, you should also see currently, 2019, there was some kind of changes in the law which actually allows patentability of these kind of genes, and there was a lot of hue and cry which is happening. Currently, people are still working on it in US, but there is a continuous discussion pertaining to whether a patent should be granted to an isolated genes. Okay, so the Supreme Court finally ruled in favor of the plaintiff. When I say favor of the plaintiff, it is the Association for Molecular Pathology. That was the plaintiff. That a naturally occurring DNA segment is a product of nature and not eligible merely because it has been isolated, thus differentiating between the concepts of invention and discovery, and stating that it does not come under the ambit of an invention. So this is very relevant to all of you here in this particular domain. So any naturally occurring DNA segment only merely because it is isolated cannot be patented. It will be considered as a discovery and not an invention. So these are the two cases which I thought I should disclose. Of course, there are several other interesting cases pertaining to the biotechnology industry. Maybe people who are interested and find these concepts really interesting and want to read, you can always read through and try to understand how these concepts have been evolved over a period of time, and what kind of inventions are patentable and what are the courts across the globe are thinking. And this decision is only in US. It does not mean the decision has been made applicable in other countries. Okay, European Patent Office has not considered this decision, but yes, some other patent offices have definitely considered, but this has been invalidated in US. Okay, I'm not saying it has been invalidated in other countries because the patent has been granted in other countries. Of course, in US, of course, in India, you can't get a patent granted because it's not allowed here, based on the Section 3 exclusion, which I just went through. So with this, I would end my session. And I think I will open the floor for any kind of question and answers you have. At any point of time, you have any queries pertaining to this patentability issues or anything pertaining to patents, you can always reach me at these numbers. You can always you can also contact KSCST team. They would also be happy to help you on these matters. Thank you very much for your kind attention, and I think the floor is open for any kind of question and answers you may have.
Participants, if you have any queries, you can either write it in the chat box or you can unmute yourself. 1 minute, sorry, query from participant. How are PCT and Budapest Treaty different or similar?
Okay, PCT is basically a patent cooperation treaty, and here it is meant for international filing of patents. So there is something called a PCT patent application, which means after you file for an Indian application, within 12 months from the date of Indian application, you can go and file for a PCT application. And once you file for a PCT application in over 130 countries, for the next or I would say for next 18 months or for the totally 30 months from the day of filing Indian patent application, you will have protection in this 130 odd countries who are all signatories to the PCT, right? And after that, within that period of 18 months or within the period of 30 months from the day you file an Indian patent application, you're supposed to go and file for patent application in the other jurisdiction of your choice. So that is PCT, which gives you an opportunity to file in countries of your choice, okay, for a certain limited period of time. So everything should happen within this 30 months period. So that's why we call it the international patent application. It is not a granting authority, but it is only a filing authority. Okay, and subsequently you will have to go and file in other countries of your choice, which would be a granting authority. Now, Budapest Treaty is primarily meant only for deposition of the biological material, which I was talking about. So PCT has got nothing to do with deposition. It only focuses on the patentability of your patent application, whereas Budapest Treaty will focus only on the deposition. It does not focus on anything else. So there are two different treaties under the WTO or under the WIPO system.
Participants, any other queries?
Ma'am, I have a question.
Yeah.
Brinda ma'am, what is the advantage of trademarking over patenting? Because that's what Coca-Cola has done.
Okay. Now, I'll give you an example. In the event Coca-Cola, or probably when you taste Coca-Cola, okay, have you ever tried to identify what kind of ingredients would have gone into Coca-Cola? Although they do specify this contains so and so, but the actual percentage of each of these ingredients is not specified, right? So Coca-Cola feels that it is very difficult for people to analyze what is the the contents of the Coca-Cola, and hence they decided to maintain it as a trade secret. The formula. Now, what you're talking about is a trademark. Coca-Cola name is trademarked, right? That is for a name. Now, the formula which has gone into the drink which you have is a trade secret. Now, what is a patent? Patent is, of course, in case Coca-Cola would have gone ahead and filed for a patent for their trade secret, they would have got a monopoly for 20 years only. After 20 years, anybody would have gone and used that particular invention without seeking permission from Coca-Cola. But however, Coca-Cola has decided to keep it as a trade secret because they felt that it is impossible for people to identify what is going into it, and hence filing for a patent would not benefit them as opposed to keeping it as a trade secret. I'll give you another example. And one thing you should understand is don't try to get confused between a trademark, a patent, and a trade secret. Trademark is only for the name, a brand name. That's it. Patent is for invention, right? And the formula Coca-Cola, yes, of course, either you keep it as a trade secret or you don't keep it as a trade secret. Now, inventions which are reverse engineerable. Okay, so for example, if you come up with any kind of a gene, and once I try to analyze it, I would know what this is all about, right? I can probably sequence the whole thing once it is in the market. Now, that is something which I can do it if you put that product into the market. Now, if you have an invention which you think, even if I reverse engineer, even if I try to analyze, I will not be able to understand what is actually going into it. Those are the inventions which a lot of companies feel it's best we maintain it as a trade secret and not protect, because we will have more value than we go and file for a patent. So that is how people, based on their business strategy, they analyze and then consider.
I hope ma'am has cleared all the queries. Thank you, ma'am, for this elaborative and very informative presentation regarding this patent. So, I, Dr. K. Valarmati, on behalf of the staff, students, and management of the Oxford College of Engineering, extend your very heartfelt gratitude for the wonderful and very valuable and very informative presentation, ma'am. Thank you so much, ma'am, for this presentation.
Thank you once again. And I would be glad, if it is actually help the participants understand some concepts about what is patentable subject matter for biotechnology invention. All the best to all of you. Thank you very much.
Sure, ma'am. We had come to know so much about the patent laws and the informations. Thank you so much, ma'am. Thank you so much. Participants, the feedback link for today's session is being posted in the